Hey y'alls. I'm assuming that this is going to be a short live because I'm genuinely tired. But I did want to still come by for just a brief moment to read a few text messages from, well, it should have been with Josh and Ange, but it's just Ange because Josh deleted his text. Though we will read one text where he decides to keep it because, well, by that point, it's the day of the New York Times hit piece, so he knows he should keep his text by that point. So that's the only one we see from Josh. Well, not the only one, but the one that we do see from Josh that he doesn't delete the text messages. High quarter fate 2. So y'all, I didn't hit. Well, if my goal is 12,000 steps, I didn't hit it. I only walked 10,216 steps today. And I was trying to think about it, and I was like, you know what? Maybe I should change my step goal down to 8,500 a day instead of 12,000. And the reason I think that it's to, well, I don't even know if I should say 8,500. I think I can, I should put down my goal to 8,000 because there's going to be days that I walk more than 8,000. But I feel like making it 8,000 is more realistic is overall. Um, because like, they say that if you walk at least 7,500 to 8,000 steps, that's where you get the most benefit. Anything above it, sure, it is beneficial, but it's not as necessary. So I feel like I should just say 8,000 is my goal because I feel like constantly saying, "Oh, I'm going to get 12,000 steps." I mean, it's tiring sometimes, and I don't feel like it. All right. Kenny said, well, first and foremost, hi, Kenny. You said, LOL, I literally finished Lauren's stream and said, okay, now I just need Pachi. What did Lauren talk about? Hi, Anna. Pam said, quick, you say. Hello, Pam. I think so, because I'm tired. But, sometimes y'all energize me where I'm like, I feel like I need to sleep. But then suddenly I'm talking about something and suddenly I'm all upset. And I get a second wind of energy. Oh, Quarter Fate 2 said, thank goodness I need a palate cleanse. Lindsay Clancy case has me down. I know there's a lot of people covering that case. I hear such varying takes on that case. I don't have a particular take on it since I've not followed it, but I know that there are folks that follow it. And, you know, I see every side of what people are saying about this case. So it's interesting just to hear how like far, like not far away, but like how vast the takes are on this particular case. Hi, Basha. Hey, Christina. Basha said, how's your water intake? I mean, I got some water right here right now. I mean, I drink a lot of water when I can. I'm more of a water person than anything else. Or smoothie. I love water or smoothies. Hi, Kiara. Anna says, yeah, I can't watch the Lindsay case. It's far too triggering for me. Oh, I'm so sorry to hear that, Anna. I mean, I haven't watched it simply because I just haven't. But I've heard a lot of it from other people. Again, people coming from various perspectives on this case. Hi, Gloria. Basha said it's polarizing. I mean, I definitely get that feel from hearing the vast differences in where people stand on this issue. Christina said, we only have heard prosecution and I need to also hear the defense, but I also don't have time to watch the actual trial. Yeah, I have not seen, I've seen that the people are sharing the trial, but I haven't sat down and watched it. And so I don't speak on it because it would be out of ignorance. I mean, so I refrain from having voicing any perspective on it because I don't have one. And all I can say is what I've heard other people say but everybody comes at it from very different takes. So it's just very interesting. Kiara said, I was hoping you would come on for a few discussions. The Lyman request of why their text should stay private in Abel's cases, and then all this Brad Pitt PR. That Brad Pitt thing, I don't know if this is going to be a polarizing take. Oh, Christina, sorry. Christina said, what is a water smoothie? No. I don't mean a water smoothie. Like, I like water and a smoothie. Like, not like a water smoothie, but like a water or a smoothie. Like, I like both kinds of things. Again, I don't know if this is a polarizing take on the Brad Pitt thing. I haven't read everything, but I read a clip where he just talks about like hints at suicidal things, and that when he was probed about what made him be in that place, and he said family stuff. And I don't know if it's polarizing, because I am definitely a person that believes that people should be able to share their own life, their own experience, all of that stuff. But there's something, and I'm just going to own it. There's just something that felt manipulative about sharing that information publicly. That I feel like, I don't know if you've ever had, okay, when I was younger, this is not at all the same, but it has the same vibe well, no, it's not the same. But when I was younger, there was this one guy at school that said to me one day, we were at school or a class together, and he sat down across from me. I can't exactly remember where he was sitting. And I remember him saying to me, do you know that my brother killed himself over a girl like you? Which was the wildest thing to me, because what does that even mean? I had like this, he was a little bit of he said he had a little bit of a stalker vibe. I mean, not really, like there was just 2 instances or so that's freaked the living daylights out of me, and I didn't know okay, so what I mean by I feel like it feels manipulative. It's kind of like putting it on his family, on his children, on his on this whole drama, as if like he's like, oh, I'm not going to actually do it. But okay, if you're not actually going to do it and all this stuff, like, why would you? That's the kind of stuff, like when somebody threatens that, it is a scary thing. And it almost forces people to stay in relationships with people because they're so afraid that that person will do something. And then it's suddenly there's like this guilt, and yet at the same time, it's like, so I don't know how to verbalize it, but I did not like it. I didn't like that interview, not because I don't think a person should have the right to share their story, but I just feel like every time the kids' names have been brought up publicly, Brad Pitt's been out there trying to push parental alienation. I feel horrible, like that my children don't want anything to do with me. And now this other aspect of like, oh, there's moments in my life that I wanted to potentially like, I could see why people would consider that as an avenue to handle things. And it's like, I don't know. I don't know. I don't like it. I don't like it at all. I know that there's going to be pro Brad folks that think that this is just him being vulnerable and just being honest. And Angelina Jolie did do all these things to alienate, but those kids are grown. They can speak for themselves. And I don't think anything that he's doing right now, because he's the only one that ends up getting quotes in the newspaper. Like, it's very hard to get anything from Angelina or the children. He's the one who keeps putting out some sort of narrative. So I feel wholly uncomfortable because I don't know if I trust the motivation behind it personally. That's just me. And again, I don't know if that's controversial. I don't know if that's polarizing. It's just what I feel. Okay, I'm sorry. Let me see where folks are at. Gloria says, I won't watch it or listen to anything about it because children are a sensitive place for me. I can't stand abuse stories of children, animals, and the elderly. Pam said, yeah, there was a couple strong opinions in Lauren's chat. Kiara said, I haven't watched it. Gloria said, Brad Pitt says, boohoo, my kids dropped my name and my ex won't give me my way. I'm drinking again. It's their fault, not mine. Ugh. Oh, did he see? I didn't get to read what else he said. The one line they quoted that I read was the whole thing about like understanding how people could become suicidal and all these different things. And it's like, I'm not saying that he does not have the right to say and share that, but my question is, what is the motivation behind that? Is that something that the public like needs to know and your kids need to know on a public scale, or is that something that needs to be dealt with on a private level? Because what does it really do except then create this whole firestorm around his children again, and then and the public who doesn't know anything, we don't know anything, right, about their family situation. And then people are all making commentaries on the children and the mom and all these different things. And it's like, we don't know, because the only one that's getting a chance to say something is him. Because Angelina, yeah, if she gets she does an interview, she'll say something. But even then, like it's been a long time. I mean, there was a People magazine article. They had to go years back to even get a quote from her. So it's like the kids haven't said anything. Like, why does he get to control the narrative? I guess I don't know. Well, I guess I do know. It's because Angelina and the children choose to stay silent. But that's why I mean, a part of me feels like it's a family situation. Why do you want to bring that stuff out to the public? What are you hoping the public's going to do with that knowledge? You know what I mean? Well, she said it's interesting that he's also brazen enough to come out as being a proud drinker. Anna said, knowing the PR business as we do now, I look at everything much deeper than just the BS they spin. Pam said, I'm thankful they didn't get weird. Lawrence had some wild experiences. I don't want her to get turned off by the internet. Kiara said, I think they are getting out PR to make him look like poor him. He's a victim and getting ready to drop his lawsuit. I don't know. It's like a woe is me. I don't know. Anna said, once you see it, you can't unsee it. Yeah. Hey, Kimberly. Basha said, is there's just some things that don't need to be said. Yeah. I don't think the things that he said needed to be said. Definitely not on a public, like, you know, I guess I just wonder, like, what benefit does that have to his children? Like, on one hand, he wants people to think that he cares so much about the kids and that all of this stuff, but he continually puts out things where it makes not only Angelina look bad, but the kids look bad. So I don't know how he thinks it's protective of his children to do half of the kind of PR he's been doing. Gloria said Brad's PR dragged Jen Aniston after he left for AJ. Now it drags both AJ and the kids now that they are adults. I wouldn't put it past his PR team to be the one who gets crazy days and nights. The blind item that AJ and her son Maddox had in it. Oh my word. Yeah. I couldn't even finish that sentence because Yeah. Anna said, can you imagine going through a freaking divorce for 10 years? Yeah. And it's interesting too, is how there's some folks that think that it's Angelina that's dragging this out when she's just wanted out. I mean, before I read the lawsuit that Brad Pitt did, I had no opinion. People can watch that first video. I'm like, I really don't know what I think. By the end of the time I finished reading that lawsuit, I had so many like feelings about like why I think that Brad Pitt heavily controls the narrative right now. And that I feel like Angelina, the fact that she sold her portion, she would have been out of his life completely. That was the last piece that was connected to him. So selling it was the best thing for her. And then he drags her back in with a lawsuit. I don't know if he doesn't want to give it up, or maybe he will give it up. I don't know. But I don't know if it's this like last ditch effort to hold on to something. You know what I mean? Basha says Darvo. Is that what it's called? I mean, maybe. I don't know. Darvo has a little bit of a bitter taste right now for me. But I mean, just because the way it was used in the other case, the terminology, I almost have to wean myself off of the negativity I felt, and remind myself truly what it stood for, and be able to genuinely answer from an unbothered place. Pam said, I think Brad's current crap is a big FU to his former family. Anna said, how much money is that? How much money is what? I'm sorry. I'm behind by like almost 10 minutes. Quarter Fate 2 said, no, a divorce for 10 years is crazy. Hey Trish. Kiara said, I'm equal on both. I don't care for AJ or Brad. Christina says, I'm a little all over the place on this one. Pam said, me too, Kiara, they both suck. Quarter Fate 2 said, haha, same. I don't have a feeling one way or another for either. I mean, and the 10-year divorce was connected to custody. That was the reason that it dragged on so long. They were both fighting around custody. Basha said, why is it news? Because I think he wants it to be news. Because it makes people feel sorry for him. That then makes them think parental alienation, which is the biggest narrative that he's tried to actively push out about this whole situation. And then it makes them like, it makes people in the public be like, oh, why aren't you talking to your dad? Like, and getting involved in a conversation that's really a family business situation. And I fully recognize that I'm here talking about it. But even as I'm talking about it, I still wrestle with the fact that he made something public that I feel like, one, it's just not our place to know, because it doesn't help him for us to know. It doesn't help the kids to know. Like, he needs to get help. If he needs to make sure that he's surrounded with the support that he needs, but it's not through the public. You know what I mean? Gloria said, it feels like trying to send the public after AJ and the adult kids viciously to me anyway. That's what it feels like to me, personally. Christina said, so then he doesn't ever talk about his children and then people attack him for that. That's the thing, though, Christina, he doesn't talk about his children. He talks about how sad he is. He talks about how like they don't want to be around, or whatever. Like every quote from Brad is a woe is me quote. Never once did I hear this man talk about his children as his children. I mean, obviously, I don't read everything, so maybe he does. But ever since this whole thing, everything is about him. It's never about the kids. The only reason the kids are ever brought up is to talk about how sad he is. Well, what about the kids? What about what the kids feel? Why is his feelings the only one that matters in this whole situation? Forget Angelina. Why is your feelings the only one that you ever talk about? You don't sit and you don't ever sit and I mean, obviously I have to watch what I'm saying, because I'm saying what he chooses to show publicly is not musings about, oh, I'm so excited to see this and that about my kids. I might not be able to be there, but like I do watch what they're still doing and I'm rooting for them or whatever. I don't hear him talk about the kids and what they're doing and how excited, because he doesn't have a relationship with them. And he can say that's parental alienation, and maybe there is. Who knows? I don't know. But all I know is that Angelina Jolie's not saying jack squat, really. I mean, it's not to say that she doesn't have any quotes. I'm just saying she doesn't put out things. She doesn't have a PR person. So if you want to have a quote from her, you need to go to her directly for something. And she doesn't sometimes want to give you anything. And then the kids don't say anything. So so I don't know why I feel so like emotionally like upset by like the idea. Like, I don't know. I don't know. Something about this triggers me, and I don't know what it is genuinely, because I try to like, I'm trying to pull myself back, because I'm like, okay, I don't know what's happening, but all I have is just what they put out in the media, and he's the one putting things out in the media. And I don't hear him talking about his children. I hear him talking about himself. So a part of me is like, if he chose not to talk about how he's feeling about being not in their lives, I don't think he would have added anything or just subtracted anything from what I thought about Brad. I would just figure that that's his right to not tell the public anything. You know what I mean? It's his family. Why should we have privy to, what's going on there? It's none of our business at the end of the day. Unless of course their life is in danger. And somehow we can do something. I don't know if that's even an accurate statement, because what can we do as the public usually? But I don't know. I don't know why I feel as deeply as I do about it. Maybe because I don't know. I need to like I need to do my own little search in my own heart why it upsets me so much when I think about stuff. Kenny said if she wanted to speak, I think she could. Absolutely. And there's a reason she doesn't. There's a reason she doesn't. It's not for our curiosity. It's not our place to know this stuff. This was like none of the things that come to light was meant to even come to light. Like even her asking for the information from the FBI about what happened on the plane. She didn't ask for it under Angelina Jolie. She asked for it under Jane Doe. And the fact that, somehow it's like, it becomes like, I don't know. Oh, I have to watch my tone. I'm feeling so much stuff and I don't know why. There's something here that's upsetting me, but I don't know what it is. Kiara, guess who his PR rep is? Matthew Hiltzig. Matthew Hiltzig. And I think that says a lot. Basha said publicity is all a game and they don't want to play. Gloria said he's been using PR to attack her and thereby the kids too. They get hurt every time his PR trashes her. Quarter Fate 2 said, oof, trash talking about the other parents always a bad idea, regardless of their age. A night, Trish. Kiara said, oops. Where is it? Kiara said, I thought they put it out about her and her brother. I didn't hear about her son. Pam said that their divorce is final. It's just the winery's lawsuit. Yeah. But that's the final straight. Like, that's the final thing. Like, once that winery thing, once she sold it, she thought that was donezo. But then he up and sues her. But then, and then the winery countersues him. But does she countersue him for anything? No. I mean, for her, once he's done with his lawsuit, there's no dragging it on for her. She doesn't want another lawsuit. She doesn't want, or I mean, I shouldn't say she does. I have no clue. But I'm just saying she didn't go in on a counterclaim. Only the company that she sold the winery to did a counterclaim. She's not part of that. She's just being sued by him at this point. Gloria said, one thing I learned through my divorce is that if I said anything negative against my kid's dad, it hurt my kids. I refused to do that after I realized what I was doing. Brad just keeps doing it. Kimberly said, he says his drinking made him lose the kids. Now he admits to drink for 2 to 3 years. No wonder the kids are done with him. He's never going to change. The thing is, Kimberly, like, he admits that he did not know how to not drink every single day. So that's why I'm saying the plane incident can't be the first time. I think it's the final straw. When you filed a divorce within days, that wasn't the last time. And I think it's because it involved one of the kids. I think maybe before it probably was just Angelina, but once she thought he was going to go after one of the kids, I think that was it for her. That's all speculation on my part. Basha said, you are so triggered. LOL. I am, and I don't know why. Pam said, yeah, I never trash talked the dad. He did a bit, though, when he drank, I guess. Had to go grab the kiddos a few times. Hey, Prish. Quarter Fate 2 said, because he's a man and they don't think about anything other than themselves. Haha, kidding, not kidding. I mean, it depends on the man, right? But yeah. Yeah, I don't know why he every time he spoke, I would be like, so it's about you again. It's always, I mean, obviously he can only talk about himself, I suppose. But I should fact check myself. Maybe there are things where he's talking about his children. It's not about like, woe is me. But usually every article I've seen is him providing quotes around how like, oh, you know. And I'm not saying that I don't feel bad for him in the sense of like, I do think he cares about his children. But I do also think that he needs to look inside himself a little bit. And instead of always blaming something outside of himself for the reason. Extraterrestrial, hello. You said new filing from Blake Lively in Texas. Oh, yeah, that's right. I mean, I don't know if that's right, but I mean, oh, that's right in the sense of like, I remember that she has a right to respond. So let me look. Let's see what it is. Wallace versus Blake versus Lively. Hi, Mari. And Sparkling Through. And D Misfit. Yeah, so again, I recognize fully, like Basha has called out, that I'm really triggered. I genuinely am. I don't know what it is. There's something that's definitely emotionally registering to me about stuff. Oh, affidavit declaration of Michael Gottlieb. Like I care. Okay, let's look at the memorandum in opposition to motion. It is 14 pages long. It is an opposition to plaintiff's motion for discovery. So let's see. Actually, let me text them. Hold on. Carol. Where's Carol? And there. Blake Lively response has come in for Jed Wallace. D Misfit said, Michael Gottlieb is my Josh. Okay. Let's see here. So plaintiffs Jed Wallace and Street Relations, Inc. seek to reopen the record and take a second deposition of defendant Blake Lively to support their opposition to a motion that was fully briefed on May 18, 2026, nearly 3 months ago. Their only excuse for the untimeliness of their request is that 2 months ago, a court in the Southern District of New York agreed with the arguments Ms. Lively raised in her April 27 fee motion, including that it is a plaintiff's burden to prove malice to avoid Section 47.1 fee shifting, both at the merit stage and under Rule 54D2. But the Wallace parties were fully aware of those arguments when Ms. Lively made them on April 27 in this case. By the deadline to oppose Ms. Lively's fee motion, May 11, the Wallace parties could have attached evidence, requested a hearing, or requested further discovery to support their opposition. They chose not to do so. The fact that Ms. Lively recently prevailed on a similar motion is not an excuse for the Wallace parties to seek a do-over on an opposition brief they wish they had litigated better the first time around. They have knowingly and voluntarily waived any right to further discovery. Further, even if their requests were timely, the Wallace party's supposed need for a deposition ignores that they have already deposed Ms. Lively on the very subject they are claiming a need to explore now. Specifically, the Wallace parties assert that they need to take Ms. Lively's deposition to determine whether she was malicious when she communicated her allegations of sexual harassment against them. Among other things, the Wallace party's counsel was able to and did question Ms. Lively on the topic at her 2025 deposition, including asking her about the very documents that the Wallace parties claimed to have constituted actionable defamation in this case. The Wallace parties do not explain what additional information they seek that they did not already have an opportunity to ask about. There's a footnote that says, to be clear, the premise of the statement is false. Ms. Lively has never once stated or claimed to anyone ever at any time that the Wallace parties sexually harassed her, and they know that full well. As Ms. Lively explained her motion to dismiss, the Wallace party's defamation lawsuit against her was based entirely on the fact that the caption of her administrative complaint before the California Civil Rights Division listed all claims against all respondents. The Wallace parties asserted that Ms. Lively had somewhat implied that Jed Wallace had sexually harassed her, ignoring the dozens of paragraphs on allegations in the CRD complaint against the Wallace parties that focused exclusively on retaliation. And there were no factual allegations whatsoever of sexual harassment against the Wallace parties. The Wallace parties ignored that issue in their opposition. I mean, I don't hate me. I do agree with that. I've always said that. She never accused him of sexual harassment. But that's why I'm wondering, why are you doing 47? Like, why do you think you get to do 47.1 on him when you know that there was no protected activity you engaged in that should affect him? And people say, well, read section 47.1. It talks about retaliation. But it's ridiculous to me, because that has to be California. Okay, California Civil Code section 47.1 provides a qualified privilege for individuals' communication about sexual assault, harassment, or discrimination, protecting them from retaliatory defamation lawsuits and allowing recovery of damages and attorney's fees. So the law protects factual communications about incidents personally experienced by the individual, acts of SA, harassment or discrimination in workplaces, educational institutions or housing, or retaliations against individuals for reporting misconduct. Like, where does she fall under here? How is, I agree with what they're saying here. They never accused them of SH. That's my point exactly. You've never accused them of SH. What right do you have to get 47.1 fees out of him? I always wondered why they don't argue that. I have wondered why they never argue that, because it's true, right? He's never been accused really of SH. However, do I also agree with him that the way that the CRD looked, you know, it could give that impression to people? Yes. But if they read the lawsuit, they would know that he was never accused of SH. And so I don't understand why they should get any 47.1 like fees, attorney's fees for this. So I guess we're going to find out what they're going to say. But I don't disagree with them on that footnote. And honestly, I don't disagree with them with what they're saying right already. They already said. Okay. I mean, I don't know. Finally, the Wallace party's motion concedes that discovery in connection with a fee motion is available only with leave of court. But for the past several weeks, they have been attempting to coerce Ms. Lively to comply with a purported notice of deposition for which they had never even sought leave of court, much less obtained it. Still, despite acknowledging that leave of court was required all along, the opening sentence of the Wallace party's introduction states that Ms. Lively acted improperly when she refused to and did not appear for her noticed August 4, 2026 deposition, and did not seek a protective order as the rules require, citing plainly inapplicable portions of Rule 37 for such a failure to appear. Motion at 2. That assertion is frivolous if not sanctionable, given the Wallace party's express concession that discovery is only authorized under Rule 54D2 with leave of court. Motion at 7 to 9. The Wallace party's cynical suggestion that Ms. Lively acted improperly by refusing to comply with a deposition notice that they acknowledge was improper appears designed to yet again smear Ms. Lively's character, or worse, pressure Ms. Lively in bad faith into dropping her claims. Either way, the motion should be denied, and the court should add the fees Ms. Lively has incurred in dealing with the Wallace party's latest stunt to her award under Section 47.1. Please. I still, okay, I'm going to continue to read to understand why in the world you think that you should even get 47.1 stuff for him. I don't get it. The background. Plaintiffs filed this action on February 4, 2025, seeking a declaratory judgment and asserting a defamation claims they anticipated Ms. Lively would file in the Southern District of New York. Ms. Lively dismissed on jurisdictional and merits grounds, after which plaintiffs filed an amended complaint, dropping the declaratory judgment action by proceeding with the defamation claim. Ms. Lively again moved to dismiss on numerous grounds, including lack of personal jurisdiction, improper venue, and on the merits. While that motion was pending, the Wallace parties participated through counsel in the deposition of Ms. Lively in connection with her affirmative claims against the Wallace parties and their co-defendants in Lively versus Wayfarer Studios et al. Counsel for the Wallace parties deposed Ms. Lively for 1 hour, with counsel for the other defendants using the other 6, and questioned her about her personal knowledge regarding her claims against Mr. Wallace, the nature of those claims, and the documents that the Wallace parties allege in this action to contain defamatory statements relating to the Wallace parties. Okay, hold on. Do we get a bit of her transcript then? Are we getting anything of her transcript then, if that's the case? Okay. We do. Okay. I'm going to leave this and I'm going to read the deposition of Blake Lively here. Okay. July 31, 2025, transcript of Blake Lively, page 246. Record and the time is 6:33 p.m. Videographer, we are back on the record, and then the time is 6:42 p.m. Babcock. Miss Lively, my name is Chip Babcock. This is Joel Glover. We represent Jed Wallace and Street Relations, Inc. Okay. Nice to meet you across the table. Nice to meet you. Sorry about the circumstances, but it is what it is. I appreciate it. I've just handed you exhibit 1000, not 1001. That's just a notice of deposition. It's not a big deal. We just like to keep records. So you're here, and thank you for being here. Exhibit 1000, marked for identification. Okay, do I need to take the time to read this? No. Okay. Blake, are you really asking if you need to read something? But anyways, just kidding. Kenny said short live. Ha! Well, now, to be fair, I did not know that this Wallace thing came out. This Blake Lively thing. Okay. Okay, you can if you want, but there is just legal gobbledygook in there, so not a problem. Would you tell me what your definition is of personal knowledge? Hudson, objection. Knowledge that I retain myself in this context without attorneys. Good. I was hoping you'd say that because all of my questions are going to be asking you about your personal knowledge. Okay. And I don't want you to rely on your attorneys, something your attorneys may have told you for reasons why there have been objections previously. Yeah. She can still object if she wants. Okay. But she doesn't have to because I'm not asking about that. Have you ever met Jed Wallace? I have not, no. Have you ever talked with him? Not to my knowledge, no. Okay, have you ever corresponded with him? Not to my knowledge, no. Do you know what he looks like? I don't. Okay, you do know he lives in Texas. Hudson, objection. I do. Okay, you listed I thought I heard. I may ask you questions you've already been asked, but I didn't catch everything down there. You listed everybody you thought had harassed you, and I don't think I heard Mr. Wallace's name. But the question is Mr. Wallace among the people that harassed you or not? Hudson, objection. I have never met Jed Wallace, so I do not think he participated in physical sexual harassment. Okay. I believe he was part of the retaliation campaign that was a result of that, and that's harassment. Were you done with your answer? Hudson, sorry, I just want to... And then it jumps down to page 253. One specific author, which would be Mr. Wallace. And are you aware of any specific article that he authored himself, maybe in conjunction with others, but that he authored himself? Hudson, objection. With his name on it? No. I understand Mr. Wallace's work to be quite clandestine. Oh, you love to throw that word around, huh? So I'm not aware of anything that has his name on it. No. How do you know his work was quite clandestine? That's how it's been described to me by everyone who knows him. That everyone who I've spoken with who knows him. How? Blake, who knows Jed Wallace? Pray tell. Who are all these people you've been talking to that know Jed Wallace? I would like to know. Who know? You don't even know what this guy looks like, and you're trusting a bunch of people who... I'm really intrigued to know who everyone is that knows Jed Wallace. But you know what? Maybe Blake says things like everyone the same way that I say always, and I can't stand it when I do it. if you watch my videos, I have this tendency to say always when I don't mean always, which bothers me when I notice myself doing it. Like, I'll say something like, oh, I always thought. No, I didn't. Sometimes I watch a video of mine and I'm like, why did you say always? You didn't always think that. Or you didn't always. I have a tendency to say always, and I can't stand that about myself. It's something I'm working on. Because when I say it, it's an inaccurate statement. It's an inaccurate statement. But maybe she uses everyone in the same kind of way. Because I'm like, who knows him, Blake? I don't know. Because you just told me you don't know this guy from Adam. Suddenly, all of these people know him that was telling you he was clandestine or whatever. Anyways, it's also what it's also what was described in the documents we received, both in the Jones Works documents as well as documents in discovery. Was it stuff that we never got? Because where did we ever read the word clandestine or get the impression? Well, actually, let's see how what the definition word for to see, like, kept secret or done secretly, especially because illicit. I never got that impression from reading. Well, I shouldn't say I never got that impression, but nah. Who described him to you as quite clandestine? You said that people told you that? Who told you that? I don't know that those were the words that were used. Sure. That was the general sort of descriptor or the general idea. Hudson, and you're excluding a counsel, Babcock, always. I was told by Stephanie Jones. Okay, I was told by Stephanie Jones about the nature of the way he works and how he works, and so Stephanie Jones. There are, well, outside of attorneys, yeah, he has that reputation. Yeah, a lot of what I know of that is through attorneys. But I also, in the messages, I don't remember if it was Jennifer Abel or Melissa Nathan who described his work as untraceable. And there were other messages so her main source, everyone she was talking about, everyone that knows him, is Stephanie Jones. Well, how does Stephanie Jones know Jed? It's one thing to say she knows of Jed, to know that Jed exists or something. But how is Stephanie Jones? How is Stephanie Jones? I mean, Kenny, how does she know what was in the messages? Because Stephanie Jones gave it to her through this quote unquote legal subpoena or whatever. But interesting that she says everyone, and in reality, it's Stephanie. It's like, oh, everyone, Stephanie. It's just like how she says and others, when it was just an other, and it was Jenny Slate, and Jenny Slate herself felt like it was done so. When it was before the filming was even over, she thought everything had been resolved. So it's kind of like it's ridiculous. But interesting, that tells you that that says a lot, okay? Why is Stephanie Jones telling you stuff? And how does she know this about Jed Wallace? Has she used Jed Wallace in the past? I have so many questions. I can't wait to hear Stephanie Jones more. Because I want to know. Inquiring minds want to know. Okay, so the three names of people who might have described him as quite clandestine would be Stephanie Jones, Melissa Nathan, and Jennifer Abel. Would that be correct? There were others. I don't know if it was Katie Case or Brianna Coslow, who also described his work in the documents that we've... Does Ms. Coslow also go by Butler? Hudson, objection. I don't know. Okay, in any event, are Ms. Case and Coslow, are they part of the conspiracy against... And then it drops down to page 277. Okay, so basically she's like, I read it in the text messages. I think that's what she's just saying. I mean, okay, fine. She's saying more than Stephanie Jones. But Stephanie Jones is the only one she had a conversation with, which I find very interesting. Because I want to know what that conversation was with Stephanie Jones. And when that conversation was with Stephanie Jones. Because the other things about the messages, so what? The interesting part to me is the whole Stephanie Jones. The Stephanie Jones of it all. So, don't remember specifically who else was there. It was a very emotional and upsetting day. It was hard for me and Isabella to continue our work. We kept breaking because we were incredibly distraught. And the statements by the Sony people that you identified were in person in Copenhagen, is that right? Yes. Okay. There were also Sony representatives in New York and in California and internationally. And my publicist, Leslie Sloan, I believe to be in New York at the time, that she called to let me know of the negativity and of the hiring of Melissa Nathan. Babcock, okay, object as non-responsive. On December 20th of 2024, you filed a complaint with the Civil Rights Division of the California agency in charge of the Fair Employment and Housing Act, correct? Hudson, objection. I'd have to read the document to know. Sure, I'm going to show it to you. That you recited it accurately. Exhibit 1048, marked for identification. Babcock, here you go. Let me hand you. Exhibit 1048, there you go. And 1048 is a 3-page document that lists Jed Wallace and street relations as two of a number of respondents to your complaint of employment discrimination before the state of California, correct? Jed Wallace's name is listed amongst the defendants, yes. And what was the second part of your question? I'm sorry. Street Relations Inc. was also listed, correct, as a respondent? Yes. All right. And this complaint was verified by your outstanding lawyer. Oh, sorry. I read that incorrectly. But I want to even read it that way. And this complaint was verified by your outstanding lawyer, Esra Hudson, who is sitting next to you, I think. Is that right? Hudson, objection. I object, Hudson. I don't think you're an outstanding lawyer. I think you're a sketchy one. And maybe that makes you an outstanding lawyer, because you give lawyers the kind of reputation that people think lawyers have, because you straight up seem unethical to me as a person, but okay. Hudson says objection. Babcock, I would object if I were you. I would object if I were you. I'm sorry. I didn't mean to laugh. But think about it. He says, and this complaint was verified by your outstanding lawyer, Esra Hudson, who is sitting next to you, I think. Is that right? And Hudson goes, objection. And Babcock says, I would object if I were you. I think they knew. There is a reason that I still laugh at. Can I just, remind folks of, let me show you the thing that cracks me up to this day. Because even though, people always sign under the penalty of perjury, right? That's normal. But look at what how Esra Hudson signed off that CRD. I, Esra Hudson, am the attorney in the above entitled complaint. I have read the foregoing complaint and know the contents thereof. The matters alleged are based on information and belief, which I believe to be true. Compare it to other verification pages. This line is typically not there. This is a CYA statement. Okay? So that's why I think that Hudson was being playful, being funny, as it was, saying, yeah, I would object if I were you too. Yeah. He says it's on the last page, I think. Yes. And she was your lawyer with respect to this complaint, correct? Yes. And the complaint indicates that there is an attachment that says, please see attached complaint for specific details. Do you remember that? Do you remember that it had an attachment? My initial complaint? Yes. Yes. Okay. Exhibit 1049 marked for identification. Babcock, let me hand you 1049. And is that the attachment? Well, I'm unable to read all of the pages right now, so I'm going to have to go on trust to know if it's the attachment. So I don't know, but does that kind of look like what the attachment was? Hudson, objection. It kind of looks like what the attachment was. Okay, if it turns out to not be, then it's going to be on me, not on you. How about that? Is that fair? Let's hope so. And then that same day, one of your lawyers, Mr. Gottlieb, sent a letter to a number of the people who are now defendants here, correct? Hudson, objection. Babcock, do you have those Gottlieb letters? I believe it's going to be 1043 through 1045. Actually, one letter with some attachments. Maybe I got the wrong number. It's this one. Exhibit 1042, marked for identification. Babcock, let me hand you what's been marked as 1042. Sorry, I stated the wrong number. Have you seen this exhibit before? It's sent on behalf of not only Mr. Gottlieb, but Miss Hudson as well. I need to take a minute to look at it to know if it looks familiar. And then it stops there. I'm like, let's just see the whole deposition of Blake. I mean, why not? Ooh, okay. Ooh, they have the emails exchanges regarding the deposition. Once it hits exhibit B, exhibit B is going to happen on page 7. And we're on page 5. Okay. We'll just read it right when we hit that part. The court dismissed the amended complaint on November 12, 2025, holding that plaintiffs had failed to establish that Ms. Lively was subject to personal jurisdiction in Texas. Final judgment was entered on April 13, 2026. On April 27, Ms. Lively filed a motion for attorney's fees under Federal Rule of Civil Procedure 54D2, arguing that she was entitled to fees for successfully defending herself against a defamation action brought against her for making a communication that is privileged under Section 47.1. Ms. Lively's 47.1 motion made perfectly clear that the relevant procedural framework for adjudicating her fee claim was Federal Rule of Civil Procedure 54D2. The 47.1 motion even asked the court to set a schedule for determining any disputed factual issues relating to the fees awards pursuant to Rule 54D2C. And the 47.1 motion made clear Ms. Lively's position that the plaintiffs bore the burden to allege and prove that the challenge statements had been made with malice and were therefore unprivileged. Plaintiffs' deadline to respond to the 47.1 motion was May 11, 2026. On that day, plaintiffs filed an opposition brief but did not submit any evidence, request discovery, or request a hearing. Ms. Lively filed her reply on May 18, at which point the 47.1 motion was fully submitted. You know, it's kind of funny that you're saying, hey, it was already done. We don't need any more stuff. And yet you were out here with the Lively versus Wayfarer case, acting like you needed more time to make your case for 47.1. How convenient that now you're using the same argument that the Wayfarer folks made, that which was like, this was fully briefed. Like, you don't need more time. Here you're like, well, it was fully briefed. There's well, you didn't seem to care about that when it was the Lively versus Wayfarer case, because you believe in rules for thee, not for me kind of thing, right? Is that what's going on? Anyways, on June 12, the U.S. District Court for the Southern District of New York granted Ms. Lively's similar motion brought pursuant to Rule 54D2 for attorney's fees under Section 47.1, Wayfarer Studios LLC versus Lively. The parties submitted competing filings that same day to notify the court of that new decision. Plaintiffs filed an advisory to the court in the form of a letter stating that the SDNY opinion concerns an issue similar but with some important differences to Ms. Lively's motion pending before this court, that they were still digesting Judge Lyman's 47-page opinion, and that they may seek to supplement the record, including without limitation whether the SDNY opinion is applicable in whole or in part of this case. To this case, Ms. Lively submitted her own notice of supplemental authority, pointing out the ways the SDNY opinion confirmed the legal arguments advanced in her 47.1 motion in this court. For example, the SDNY opinion confirmed that Rule 54D2 supplied the relevant framework under Rule 54D2, where if a defendant prevails in a California law defamation claim and that a defamation plaintiff bears the burden to establish malice at every stage of the litigation and must ultimately prove malice at trial to avoid application of the Section 47.1 fee shifting right. Even sufficiently alleging malice is insufficient to avoid fee shifting if the plaintiff does not ultimately prevail at trial. In each case, Ms. Lively cited the portions of the 47.1 briefing that had already addressed those issues. Plaintiffs did not attempt to supplement the record. Instead, plaintiffs tried a different tactic. On June 13, more than 2 months after their deadline to oppose the 47.1 motion, and more than a month after the SDNY opinion, plaintiffs served a purported notice of deposition on Ms. Lively, noticing her for deposition on August 4. The same email demanded that Ms. Lively finalize a settlement with the Wallace parties by the same date, or Mr. Wallace would end negotiations and take his chances in court. Okay, so let's read that. So that's Exhibit B, and it's 7 pages. And we're going to start off with July 13. So let me get that open. So July 13, we've got an email from Chip going to Michael and CC'd a bunch of other people. Subject: notice of deposition for Blake Lively in New York on August 4, 2026. Separate email regarding further settlement discussions pursuant to Rule 408. Dear Michael, I enclose the attached pleading noticing your client for deposition on August 4, 2026 at 10 a.m. in New York City at Lankler, Siffert, and Wohl. Given the delay in scheduling this deposition while we discuss settlement, my client will adjust the date, time, or location for the convenience of the witness or you, but only if there is an agreed upon firm date, time, and location acceptable to my client, and there will be no effort by your client to quash or seek protection from the deposition at any time. The remainder of this email relates to our ongoing settlement discussions, which must be finalized by August 4, 2026, or my client will end negotiation and take his chances in court, as will yours. So Michael responds back, Chip, the purported notice of deposition you emailed earlier this week without leave of court has no legal basis. As you know, the Wallace party's complaint was dismissed in its entirety for lack of jurisdiction on November 12, 2025, and final judgment was entered on April 13, 2026. Thus, you had no authority to send Ms. Lively a notice of deposition under Rule 30, as courts do not grant discovery based on a complaint that has already been dismissed. In regards to German Auto, I don't know if that's, I'm not going to read all the names there. I don't know. After the district court had dismissed the complaint, any request for discovery was moot. If you are aware of any contrary authority, feel free to provide it, although I would recommend you consult the position that you and Joel advanced on behalf of the Wallace parties when Judge Lyman dismissed Ms. Lively's claims against her clients on July 16, 2025, there with leave to amend. You argued then that your clients were no longer parties for purposes of Ms. Lively's deposition, which had been noticed for July 17, and would only consider themselves bound by Rule 30 with respect to the deposition if Ms. Lively amended her complaint that day to make the Wallace party subject to a live pleading. Following the same arguments you made in the SDNY action, as well as every case we have found, your post-judgment notice of deposition is null and void. To the extent you are hoping to take Ms. Lively's deposition based on your own interpretation of Judge Lyman's order granting Ms. Lively relief under California Civil Code Section 47.1, I have already explained to you why your interpretation of Judge Lyman's order does not make sense as applied to the posture of this case. In any event, your personal musings about the possible implication of Judge Lyman's order do not arm you with unilateral legal authority to issue deposition notices in litigation that was dismissed with prejudice. That's true regardless of whether you are purporting to rely on Rule 30 as explained above or Rule 54D, which does not permit discovery except by leave of court, which you did not seek and did not have when you sent this purported notice. On rare occasion, the court may determine the discovery under Rules 26 to 37 would be useful to the parties, emphasis added. Nor would you obtain leave if you sought it. Ms. Lively's fee motion is fully briefed, and the Wallace parties waived their right to seek discovery when they elected, fully advised by able counsel, to oppose Ms. Lively's Rule 54D application on the existing record without seeking additional discovery, just like the Wayfarer parties in the SDNY action. Considering the record closed in part because the Wayfarer parties have not requested discovery or a hearing. You appear to be taking the position that you did not understand until Judge Lyman's order that discovery might be necessary to satisfy your burden under Section 47.1. But Ms. Lively fully briefed and discussed your burden in her fee motion, and the Wallace parties elected, notwithstanding these arguments, not to request discovery and to submit briefing on the existing record. Hi, Freckles for Days. For present purposes, you and your clients are on notice that you should pursue this frivolous discovery. For present purposes, you and your clients are on notice that should you pursue this frivolous discovery, Ms. Lively will continue to be represented by all of the attorneys you are communicating with here, and all the fees and costs that go into opposing your discovery will be added to the fee total we will submit to the court. I know you have reviewed Ms. Lively's fee motion in SDNY, so your clients are also on notice about the hourly rates charged by Ms. Lively's attorneys. Should you elect to proceed down this path, the Wallace parties will have no arguments that they were unaware of the potential cost of doing so. Furthermore, should you seek leave of court to take a belated second deposition of Ms. Lively, we'll remind the court that you already had one bite at this apple. Along with opposing your request, we will request in the alternative to our opposition, leave of court to serve discovery to ensure that any record beyond the pleadings is not artificially and improperly one-sided. This will include document discovery on your clients for the many, many documents we know were not produced during discovery in the SDNY action, including those we learned of before, during, and after his deposition. And we will also seek depositions of your clients, along with the depositions of at least Melissa Nathan, Rosa Kalantari, Brian Friedman, Katie Case, and Jamie Heath. Interestingly, Justin Baldoni's not listed there, but probably because Justin was really kept out of the loop. Because Jamie was the main contact for everything. So I'm not surprised by that. And Jen Abel's not listed on this thing either. So, I mean, that makes sense. The list here makes sense to me based off of what they're asking for. Of course, should you force the parties into belated and expensive discovery notwithstanding your motion, we will seek reimbursement of all the costs and expenses of such discovery. For your settlement or correspondence, I'll address that by separate email, as I'm sure you did not intend to link your threat to take discovery with zero legal authority with a settlement demand. I'm not a lawyer, but all of that makes sense to me. So, but I'm sure I'm waiting to hear what a lawyer thinks about all of this, the things that is being said. Babcock said, "Dear Michael, in light of the below, I assume that Ms. Lively will not appear for her notice deposition on August 4, 2026, next week in New York. So that I do not incur unnecessary travel expenses, would you please confirm that today or in any event not later than Friday? Thank you in advance for this courtesy." Sent from my iPad. I don't... Sent from my iPad. That reminds me of Ellen. Do y'all remember that email with Ellen? And who was going off? I don't remember if it was Michael or Esra. And she's like, okay, or whatever. It was like, anyways. Oh, my word. July 29, Mike responds, Chip, I explained this in my July 17 email. The notice you sent is not a valid deposition notice. It was and remains powerless to compel anyone's appearance anywhere. Would your client show up if we emailed you a similar notice? Of course not. I expect you know this because in the 12 days since I sent the email below, neither you nor your very capable colleagues have been able to come up with a theory, let alone a citation to a case, rule, or statute that would provide any basis for setting a deposition notice without leave of court in a case in this posture. Of course, if you'd like to send us any citations providing legal authority for taking discovery in this matter at this point, we'd certainly be happy to consider them in evaluating your position. Respectfully, Mike. And then same day, Chip says, Michael, I did not mean to suggest that in the 12 days she had to think about this, that your client had changed her mind. But as an optimist, I always have hope. Thank you for your courtesy in promptly confirming that Miss Lively does not intend to appear at her deposition. As for authority, my very capable colleagues did not come up with anything I have not already told you, which is we rely on the pendency of your post-dismissal motion, the issue of malice in light of Judge Lyman's ruling prompted by Miss Lively's legal position in the SDNY and in this case, and Federal Rule of Civil Procedure 54. I know you and your very capable colleagues have evaluated our rights and Miss Lively's responsibilities in light of those authorities. Sincerely, Chip. Oh, folks, y'all so funny. And then Michael responds back, Chip, given your written concession that you are relying upon Rule 54, which does not authorize discovery absent leave of court, your statement that Miss Lively did not intend to appear at her deposition is a material factual misrepresentation. Miss Lively appeared at her deposition. You were there, and you conducted an examination. There is no further deposition for her to appear at unless and until you obtain permission from the court to conduct discovery in this dismissed action. And as the advisory committee notes to Rule 54 make clear, it is rare for the court to determine that discovery would be appropriate. You are advised not to repeat the above misrepresentation, whether to the court, the press, or any third party. We reserve all rights should you choose to do so. I'm not mad at Michael's email, to be honest. I mean, what this email says versus how Chip wrote his letter. I mean, wrote what he wrote. I understand why he said, don't repeat this. You know what I mean? Like, it sounded more like a threat in Chip's letter than what I actually read in this email. And this email, like, I read it as, I don't want you to repeat this because this is a misrepresentation. And I feel like some of the narrative framing was moved around on the emails. Like, it's not exactly how the conversation went. So, I mean, I love Chip. I think he's hilarious. But I hate to admit it, but I get, I get what Gottlieb is saying here, but I really prefer a lawyer to say stuff because they're going to catch things that I don't catch because I'm a lay person. I mean, or whatever. Like, I don't know. I don't know if there's like, you know how like lawyers like drop little hints of things with each other and like another lawyer will pick it up. Like, I don't pick it up. Sparkling says, Gottlieb getting a taste of his own misrepresentation medicine. That's true too. It is kind of, I mean, good point there, Sparkling, because it's like, it's laughable that, like, it's laughable that Gottlieb cares about misrepresentation when he's misrepresented a lot in his own case. So it's kind of like, kettle, pot, I don't know, glass, stone, rocks, whatever. But he's a little bit, I mean, I get what Michael is saying here, but I want a lawyer to weigh in on that. And I do find it hypocritical for him, but whatever. I still understand where he's coming from. Sparkling said, yeah, after Lively's claims got dismissed 10 of 13, he misrepresented so much. D Misfit says, oh, yes, Chip is doing a Michael for sure. They are doing a Lively. Contextually true. I mean, yeah, if you're going to talk about things were technically true. But I think that reading the emails for myself, I wouldn't have represented it the way that Babcock did. Is a great narrative, but I don't know if I would have gotten that from reading those emails the same way. But yeah, definitely prefer to hear what a lawyer says, because they'll pick up on little nuances here and there that I would not. But just from a basic read, I'm like, okay, I actually understand where Michael's coming from here. But other lawyers will be able to pick up on, like, is that a valid argument that Michael is saying? Did they need to get a leave of court to do discovery, or they're not getting a leave of court or whatever? Blah, 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 blah. But sometimes short and sweet also tells me sometimes people feel like they need to say a lot because they're trying to convince people of something. I feel like Michael would go through this whole long thing and Chip would respond back with like a whatever he did. I mean, I'm sorry. Whenever they go with sent from an iPad, I really want to find that Ellen text message where she's like, oh my word, sent from an iPhone or whatever. I don't know. It's just funny. I mean, I know my people might be like, oh, it's too casual, but it there is something like an exasperation that's that they have with them. I don't know. Sparkling Through said maybe this also makes the judge hurry up and make a decision. Maybe, hopefully, we'll see. So counsel for Miss Lively responded on July 17, explaining that the purported deposition notice was a nullity, as there was no legal basis to notice a party's deposition under Rule 30 following the entry of final judgment dismissing plaintiff's claims. That no party had sought or obtained leave to take any discovery, much less a deposition regarding Miss Lively's Rule 54D2 motion. Ms. Lively's counsel also explained that the Wallace parties had waived their right to seek discovery when they opposed Ms. Lively's 47.1 motion on the existing record, and that the record on that motion was accordingly closed. The Wallace parties never provided any authority supporting the validity of their purported deposition notice and expressly conceded that their notice relied on Rule 54. The argument. The Wallace parties have waived any request for discovery in connection with Ms. Lively's motion. As all parties agree, the sole conceivable basis for discovery in connection with a post-judgment fee application is Rule 54D2C. That rule provides that whereas here, a party seeks attorney's fees under Rule 54D2, the court must, on a party's request, give an opportunity for adversary submissions on the motion in accordance with Rule 43C or 78. Rule 43C, in turn, permits a court to hear testimony live or via affidavit. But like Rule 78, which concerns the manner of hearing motions, is silent as to discovery. And the advisory committee's notes to the rule state that on rare occasion, the court may determine the discovery under Rules 26 to 37 would be useful to the parties, citing for comparison Rule 6 of the rules governing Section 2254, cases in the U.S. District Courts, which provides that a judge may, for good cause, authorize a party to conduct discovery, and that a party requesting discovery must provide reasons for the request. If the Wallace parties wished to request leave to take discovery to support their opposition to Ms. Lively's motion, the applicable procedure was clear, and they could have requested not only discovery but an evidentiary hearing on Ms. Lively's 47.1 motion. But they chose not to do so. The Wallace parties have knowingly and voluntarily waived any right to seek leave to take discovery and have instead consented to resolving the 47.1 motion on the existing record. As is well established, a party seeking leave to take discovery must have pursued that discovery diligently. And courts in this circuit have commonly concluded that a party who decides to depose a witness outside of the discovery timeframe has failed to act diligently to the extent required to reopen discovery. In the specific context of Rule 54D2 motions, one court in this circuit has rejected an attempt to seek an evidentiary hearing after the briefing on the fee motion had been completed, noting that Rule 54D2 does not grant a right to a post-trial adversary proceeding, only an opportunity for adversary submissions. Because the party requesting a hearing has already filed its adversary submissions, its request for a scheduling order is denied. A motion for further discovery is clearly a motion in relation to defendant's opposition and plaintiff's fee motion. The time for filing this motion was at the time of defendant's opposition, not after the court had taken the matter under submission 3 weeks prior. Judge Lyman issued the SDNY opinion in the exact same posture, noting that Rule 54D could authorize discovery on rare occasion. He observed that in that instance, the factual record with respect to liability on Lively's Section 47.1 motion is closed. The motion was fully submitted months ago, and the Waiver parties had not requested discovery or a hearing. Judge Lyman considered the evidence that the non-movements had submitted in connection with their fee opposition, but held that it was insufficient to satisfy their burden to prove malice. Here, the Wallace parties, who filed their opposition brief months after the Waiver parties had submitted evidence in opposition to Ms. Lively's fee motion in the SDNY opinion, did even less, declining to submit any evidence whatsoever in connection with their opposition. The record on 47.1 motion is closed, and the Wallace parties have nobody but themselves to blame for how they chose to litigate it. Hey, Gelth Walker. I hope you can get your nap in. The Wallace parties raised two arguments for why their failure to make a timely request for discovery should be overlooked. Both are meritless. First, the Wallace parties assert that the SDNY opinion supports the motion for discovery and imply that its issuance on June 12 somehow excuses their failure to seek discovery when opposing the 47.1 motion on May 11. But as discussed, the Wallace parties had all of the same information available to them at the time their opposition brief was due, both under the plain text of Rule 54D2 and the advisory committee's note that they now cite, and by reading Ms. Lively's own opening brief. The Wallace parties appear to be arguing that they are not on notice of Rule 54D2's fact-finding procedures at the time, and have only become aware that they had an opportunity to seek discovery now that Judge Lyman's opinion has confirmed that Ms. Lively was right, and Ms. Lively filed a notice of supplemental authority on June 12, stating that respondents bear the burden to prove Lively's malice, and even sufficiently alleging malice is insufficient to avoid fee shifting. But that is preposterous. Ms. Lively took exactly the same position in her 47.1 motion and 47.1 reply, 47.1 motion at 12 to 14, 47.1 reply at 7 to 8. The Wallace parties' reliance on Ms. Lively's notice of supplemental authority is simply an excuse for not having prepared themselves for the possibility that she might be right. I mean, I'm thinking about that sentence. Hi, Akasha's piece. That statement, the Wallace party's reliance on Ms. Lively's notice of supplemental authority, is simply an excuse for not having prepared themselves for the possibility that she might be right. And I don't know what it is about that line that kind of cracks me up, because that does say something. What if he's telling the truth? What if they thought that she was so far from being right that there's no way that the judge was going to ever think she was right? That is a possibility. that they never thought of the possibility that she might be right. I don't know. But I just do find that sentence funny. Second, the Wallace parties assert that Ms. Lively blocked discovery while their amended complaint was still pending. That is simply false. The Wallace parties moved to commence discovery before the court had issued an order requiring the parties to confer pursuant to Rule 26F. The court then set a deadline for the parties to confer, which they did on November 11. The court granted Ms. Lively's motion to dismiss the following day. And although they could have avoided any dispute about personal jurisdiction simply by refiling or filing in the first place in New York, oh, that's rich coming from y'all's, the Wallace parties have not done so. In other words, Ms. Lively did not block discovery. The reason that Wallace parties not take discovery in this action is that the complaint was dismissed before it could happen. Meanwhile, the Wallace parties were simultaneously and repeatedly moving to stay discovery in connection with Ms. Lively's claims against them in New York. Suggesting that Ms. Lively is in any way at fault for blocking discovery and aided the Wallace party's frivolous complaint is absurd. I'm sorry. I just roll my eyes at the statement of how they could have avoided any dispute about personal jurisdiction simply by refiling or filing in the first place in New York. Like, you're one to talk. Y'all knew that you shouldn't have been filing in the jurisdiction that you did, but you did it anyway, didn't you? Anyways. Footnote number 2. Then as now, the Wallace parties represented that they had multiple attempts to engage defendant in a conference pursuant to Federal Rule of Civil Procedure 26F beginning on June 16, 2025. That is false, as Ms. Lively's local counsel had heard nothing from the Wallace parties between June 16 and July 17, the day before the Wallace parties filed their motion, during which time Ms. Lively's local counsel was dealing with the aftermath of catastrophic floods okay, hold on. I'm sorry. Are you? Then, as now, the Wallace parties represented that they had multiple attempts to engage defendant in conference pursuant to Federal Rule of Civil Procedure 26F, beginning on June 16, 2025. That is false, as Ms. Lively's local counsels had heard nothing from the Wallace parties between June 16 and July 17, the day before Wallace filed their motion, during which time Ms. Lively's local counsel was dealing with the aftermath of catastrophic floods in Kerr County. I'm sorry. So the irony that you're going to bring that up, and you had a heyday. You had a heyday when people brought up the fact that you tried to, that the subpoena was trying to be served during the fires in California. So it was wrong for them to bring that up when they brought that up. But here we're supposed to care about that. You were dealing with like, you didn't care before. Like, that's real. I don't know. I think sometimes I get so frustrated with just the hypocrisy that's embedded in so much of what Michael's saying. It's like, but I mean, I guess that's how it works, right? They will argue against something in one case and then use that same argument in another case, because at the end of the day, that's what lawyers do. But it's just the hypocrisy is wild to me. About like, oh, we were dealing with this. Well, you didn't care about the other one. You didn't understand. Kiara said he doesn't care. He's getting $2,350 an hour. Kenny says hypocrisy is my biggest pet peeve. Pam said, oh my God, floods versus fires on his primary residence. That's her second residence. Well, they're talking about Lively's counsel. So not Lively herself, but Lively's counsel were dealing with the aftermath, which was the same situation with Brian Friedman and the fires. And yet they made a big deal about like how that was not a big deal. Why are you bringing that up? This is just for headline purposes. Blah, blah. So it's going to be interesting to see if there's supposed to be a headline purpose of this, of how it's going to be interesting. Sometimes I wonder if we should ever like bet on which statements they intentionally wrote into certain filings so that they can bring it to a news outlet so they could write around that particular statement. I wonder if there's going to be certain things that we'd want to guess will be used by a news article or a news outlet around this response from Blake Lively, if they happen to even try to push out stories about it. Confronted with that misrepresentation, the Wallace parties had no response, stating that they did not believe it's necessary or productive to engage in further debate regarding the points made in Miss Lively's response. Okay. Further, all of this ignores the fact that the Wallace parties have already deposed Miss Lively on these exact issues. In response to questioning from the Wallace party's counsel back in 2025, Miss Lively testified that she had never met Mr. Wallace and was not claiming that he sexually harassed her. And she further explained that her claim against Mr. Wallace related to his role in the retaliatory smear campaign against her for raising concerns about sexual harassment. Mr. Babcock questioned Miss Lively about her personal knowledge of Mr. Wallace's role in the retaliation campaign, even asking her to explain her understanding of personal knowledge. Her answers distinguished between information that she had learned from documents from her attorneys and from her personal observations. And Mr. Babcock even questioned about the very documents that the Wallace parties alleged to contain defamatory statements in this case. If the Wallace parties thought that Miss Lively's testimony was helpful to their opposition, they could have sought to submit it by the May 11 deadline, but they did not even attempt that. The Wallace parties should not be granted a do-over to gin up publicity and pressure her to drop her claims. The Wallace party's purported notice was frivolous, as the Wallace parties now concede the only conceivable basis for seeking discovery at the stage is Rule 54D2, which permits discovery only in rare circumstances and only with leave of court. Motion at 7 to 9. That confirms that the notice of deposition that the Wallace parties purported to serve on Miss Lively was frivolous and utterly without legal basis for weeks. For weeks, the Wallace parties took the position behind closed doors that Miss Lively was bound by a piece of paper that they now concede has never had any legal basis whatsoever. Their suggestion now that by ignoring that notice, Miss Lively somehow failed to appear for a deposition is absurd. Tellingly, the Wallace parties do not have the temerity to ask for fees or sanctions in connection with that purported failure, nor could they, given their concession in the same brief that such a notice could only have been valid with leave of court. It is indefensible even to suggest that Rule 37 sanctions could apply to Miss Lively's refusal to put up with a lawless deposition notice, and can only be understood as a further attempt to attack Miss Lively's reputation with unsupported accusations of wrongdoing that Mr. Wallace can then propagate into the social media universe. The only alternative is worse, namely that the Wallace party served the sham that. I'm sorry. Don't you dare. Don't you stinking dare. Every time you write the sham, I just want to like throw up in my mouth. Don't you dare try to take authorship when you know what you're trying to do with even having the audacity to use the word sham. Okay? Ew. Stop it. Michael does this a lot. He keeps trying to make sham like he's trying to take over like that whole thing because they want to like shut down any Van Zandt conversation, and I can't stand it every time I see him use it. It's he drives me up the wall sometimes. Less so than Esra Hudson, only because I had higher expectations for her. I thought she had a better moral compass, but what a disappointment. Anyways. Hi, Mama Panda. I feel like I haven't seen you in a bit. It's good to see you. You're like, stop trying to make sham a thing. Yeah. I mean, unless you're talking about Van Sham, stop it. The only alternative is worse, namely that the Wallace party served the sham deposition notice, not because they thought they had any basis to do so absent leave of court, but as a leverage play to pressure Miss Lively to drop her fee claims. Why would she feel the pressure? Why would she feel pressured to drop her fee claims? Let's say they had a leave of court and they got the deposition. Would you still feel like it's pressure for her to drop her fee claims? The circumstances of the Wallace party's initial email to Miss Lively's counsel speak for themselves, as does the Wallace party's later concession that there was no lawful basis to serve a deposition notice at that time. They did no such thing. Just because they didn't answer your question to your satisfaction does not mean they made any concession of such thing. Miss Lively is entitled to the fees incurred in litigating this motion. It is undisputed that if the court grants Miss Lively's fee motion, she's also entitled to fees on fees. That is the fees she incurred in litigating her fee motion. That amount should also include the fees she has incurred in litigating this motion, which is nothing more than an attempt to reopen a dispute that the Wallace parties wish they had litigated better the first time around. Conclusion, the motion should be denied. Respectfully. Oh, it was Laura Lee Prather? Oh, okay. Now I can't even be mad. I can't even be mad because those are not coming from Michael Gottlieb. It's coming from Laura Lee Prather. I'm less upset because the hypocrisy that I have tied is if Michael was saying it. I don't know Laura Lee Prather from Adam. So her saying the same things that if it came out of Michael Gottlieb's mouth, I would have felt what you saw I felt. But now knowing it's Laura Lee Prather, I'm like, I still think there's a lot of hypocrisy, but I don't know how much her level of hypocrisy is because this is the first time I'm seeing something from her. For all I know, she could, whatever. But why is Laura Lee Prather the one writing it? Why is Laura Lee Prather writing it? It's kind of like, it reminds me of like when Michael Gottlieb, with that whole situation with Taylor Swift's lawyer, how he had Esra Hudson write the letter. When it's like, why are you not writing the letter? So why does Laura Lee write this letter? When all of the emails was between him and between Michael and Chip or Charles. Like, what's the purpose of that? Why are you going to have some random other person write the response? She's had more. I mean, yeah, because this one's the Texas one, so she brought in a Texas thing. So the undersigned certifies that on the 12th day of August 2026, a true and correct copy of the above document was served via the CMECF system to all counsel of record, Laura Lee Prather. I just don't understand, why would you not have Gottlieb be the one that writes it? That's why I was all getting upset, because I thought it was Gottlieb writing it. But if it's Laura Lee, it's like, but why you? You weren't even any of the email back and forth. Like, why can't he speak for himself? Oh, Laura is the Texas lawyer. Gottlieb is pro hoc vice. So what does that mean, pro hoc vice? Does that mean he can't write a letter? Okay. In the legal field in the United States, admission pro hoc vice is a practice in common law jurisdictions whereby a lawyer who has not been admitted to practice in a certain jurisdiction is allowed to participate in a particular case in that jurisdiction. Sparkling Through says, I think he can, but I noticed Brian Friedman hardly wrote in New York. But I mean, I feel like I would have to look back. But did Brian respond to things that were associated with Brian? I don't know. I would have to look back. But I certainly noticed that Michael doesn't respond to things that he would be the most knowledgeable about. So Pam said procedural rules. He's a guest. Well, oops. I don't know what I would feel about that. About him being a guest. Not in regards to like what pro hoc vice actually is, more than like I don't want him to ever be a guest. I guess. I don't know. Anyways, okay. But thanks for letting me know if that's why. He's not the one writing the letter. But how come he can write a declaration if he's not writing? Well, I don't know how that all works. That's why I need to have a lawyer person. Because sometimes something gets me upset and it's like there's a reasonable reason for it. And I shouldn't be upset. All right. Declaration of Laura Lee Prather in support of defendant's opposition to plaintiff's motion for discovery. Pursuant to 28 U.S.C. 1746, Laura Lee Prather declares, my name is Laura Lee Prather. I'm over 21 years of age and I'm fully competent to testify about the matters contained herein. I'm a partner at Haynes and Boone, LLP, and represent defendant Blake Lively in this case. The following statements are made within my personal knowledge and are true and correct. I submit this declaration in support of Ms. Lively's opposition to plaintiff's motion for discovery. On October 23, 2025, this court ordered the parties to the above captioned action to submit a proposed scheduling order within 30 days. On November 11, 2025, counsel for the parties met and conferred regarding a proposed schedule pursuant to Federal Rule of Civil Procedure 26F. I hereby declare, under penalty of perjury under the laws of the United States of America, that the above is true and correct. Executed this day of August 12th, 2026. That's all you can attest to? Again, that's why I'm like, why does she write the letter? But okay, fine. I mean, there are things in that letter that certainly read like Michael Gottlieb to me. So what if it was Michael Gottlieb and they just had her sign? I'm just kidding. Anyways, just playing, kind of, maybe. Not really. Declaration of Michael J. Gottlieb in support of defendant's opposition to plaintiff's motion for discovery. Pursuant to 28 U.S.C. 1746, Michael J. Gottlieb declares, my name is Michael J. Gottlieb. I'm over 21 years of age and am fully competent to testify about the matters contained herein. I'm a partner at Wilkie, Farr, and Gallagher, LLP, and represent defendant Blake Lively in this case. The following statements are made within my personal knowledge and are true and correct. I submit this declaration in support of Ms. Lively's opposition to plaintiff's motion for discovery. Attached as Exhibit A is a true and correct copy of certain excerpts of the transcript of the deposition of Blake Lively taken on July 31, 2025. Attached as Exhibit B is a true and correct copy of an email exchange with counsel for plaintiffs regarding their purported notice of deposition directing Ms. Lively to appear for a deposition on August 4, 2026. I hereby declare under penalty of perjury under the laws of the United States of America that the above is true and correct. Okay. So his was equally short. Okay. All right. I guess that's it. That's where things are right now. Let's see if there's any news about this showing up on her news feed. Oh, you know what? This is dang. Let me Google. Okay, so the 4 stories that come up. Blake Lively is done staying quiet about Taylor Swift fallout. Insider. Exclusive Blake Lively versus Justin Baldoni legal battle sparks another bitter lawsuit. Blake Lively and Justin Baldoni's legal battle has a surprising new casualty. And Blake Lively shares a rare look at family life with Ryan Reynolds. One was 1 day ago, 4 days ago, 13 hours ago, and 11 hours ago. But that's kind of, so there's nothing right now that has anything to do with this particular case. What is this story? So they're saying Taylor Swift, blah, blah, blah. Okay, what? I don't care. Okay, according to a closer online report, the 2 women's friendships had already collapsed. The outlet said Blake was absent from Swift's July wedding to Travis Kelce. It also noted that Justin Baldoni spoke in an Instagram video with wife Emily Baldoni. He said they had not spoken publicly for the better part of the last 2 years. Emily added there is so much more to say. The report said that raised pressure around Blake's next move. Meanwhile, the source claimed Blake could decide to respond. The insider said the longer that Blake is vilified, the more likely she would speak. They added that any response would be about clearing her name and telling her side. However, the source said that would be a worst-case scenario for Swift. The insider claimed the singer was incredibly sensitive about private details she had not approved. Still, the report said Blake would not target her former friend directly. The source claimed she would never go all scorched earth on her. But after years of friendship, the insider said Blake knew a whole lot about Swift. The source also claimed another public response could put Taylor back in the news cycle. For context, Closer Online linked the split to the It Ends With Us dispute and private messages. It said Taylor had already cut Blake out of her life. For Blake, speaking out was framed as a defense, not revenge. Okay. I wonder if this article is about Vituscka or not. Oh, blast it, I did it again. Oh, it is. The legal war between Blake Lively and Justin Baldoni is now creating a fallout beyond the actors themselves. A showbiz reporter who found himself pulled into the increasingly bitter dispute after his private messages became part of the court record is now suing his former employer. James Vituscka claims the Daily Mail retaliated against him after his involvement in the case. While the newspaper strongly rejects his account, his lawsuit adds an unexpected workplace battle to an already sprawling Hollywood feud. James Vituscka was covering the It Ends With Us controversy as a senior U.S. entertainment reporter when his conversations with people on both sides of the dispute unexpectedly placed him inside the legal battle. According to his court documents obtained by Page Six, Blake Lively's longtime publicist Leslie Sloan told him in August 2024 that Baldoni was the source of tension on the film set, but Vituscka said she did not tell him that Baldoni had sexually harassed or assaulted Lively. After the Gossip Girl actress filed a sexual harassment complaint against Baldoni in December 2024, Vituscka says he contacted the director's crisis manager, Melissa Nathan, about the apparent discrepancy. During the exchange, he accidentally used the words SA rather than SH, but maintains that he subsequently clarified that Sloan had never told him anything about sexual harassment. Those messages eventually appeared in Baldoni's legal filings, thrusting Vituscka into the middle of the dispute. He claims his comments were selectively quoted and stripped of context, after which he was subpoenaed for documents and testimony. Vituscka's involvement allegedly became a problem not only in court but also at the Daily Mail. His lawsuit claims that the subpoena triggered a disagreement with the newspaper over how he should respond, eventually leading to changes in the way his work was supervised. He alleges the newspaper discouraged him from obtaining his own lawyer and instead pressured him to sign a declaration containing language he was uncomfortable with, including a statement that he regretted the actions that led to his involvement. Vituscka claims the treatment ultimately resulted in his termination in June 2025. His lawsuit, filed Monday in Manhattan Supreme Court, accuses the Daily Mail of whistleblower, retaliation, sex and disability discrimination, sexual harassment, interference with protected rights, and wrongful termination. He is seeking damages that include lost wages, emotional distress damages, and punitive damages. The complaint has not yet been reviewed by the county clerk at the time of publication. The Daily Mail has categorically denied Vituscka's allegations and rejected his description of how the declaration came about. In a statement to Page 6, the newspaper called this lawsuit an inaccurate account of the circumstances surrounding the declaration he signed in connection with the Lively Baldoni litigation. The outlet specifically disputed that the claim that Vituscka was pressured into signing something he believed was untrue. At no point did Daily Mail pressure James to sign a declaration he believed to be untrue, the newspaper said, adding, in fact, the declaration he signed was consistent with what he had already told senior management after the Baldoni complaint first came to our attention. The Daily Mail also defended its expectations of its journalists, saying, as a trusted news organization, come on. Come on. Just because you call yourself a trusted news organization doesn't make you a trusted news organization. Come on. You're a tabloid at best. I mean, I think you see yourself, you have a higher opinion of yourself than people have about your publication. We expect our journalists to act with honesty and integrity, and we rely upon that important expectation. The newspaper went further, rejecting Vituscka's characterization of himself as a whistleblower who suffered retaliation or discrimination. It said his claims that he's a whistleblower who suffered retaliation, harassment, discrimination, or other unlawful treatment are entirely meritless and unsupported by the facts, and we are confident they will be soundly dismissed. The dispute, therefore, leaves Vituscka fighting a separate legal battle over what happened after his reporting became entangled with the Blake Lively and Baldoni litigation. The fallout surrounding Blake Lively's legal battle has continued to spread into new corners, with another dispute now putting the actress back in the middle of a court fight. A few days ago, TMZ reported that Jed Wallace, the Texas-based PR consultant who worked with Justin Baldoni's team during his legal battle with Lively, was seeking another opportunity to question her under oath. The request came as Lively pursued legal fees tied to litigation, creating a fresh dispute even after Wallace's own case against her was dismissed. Lively's attorney strongly opposed the request, arguing that Wallace had already had his opportunity to depose her. They characterized the move as another desperate, meritless attempt by Wallace to go after Miss Lively, according to a statement to the outlet. Wallace's request concerned questions surrounding Lively's bid to recover hundreds of thousands of dollars in fees and costs from him. His attorneys argued that they need additional information before the money could be released. Well, it's not even before the money could be released. I mean, the judge hasn't made any decisions on that, but the dispute over Lively's legal costs stemmed from a much larger financial request she made after her litigation with Justin Baldoni moved toward a settlement. In June, the blast stated that Lively asked a federal judge to award her approximately $8 million to cover legal fees and expenses connected to Baldoni's now dismissed lawsuit against her. Her filings sought about $7.5 million in attorney's fees, along with roughly $540,000 in additional costs. Those expenses included legal research, travel, and meals accumulated during the lengthy litigation. Lively's attorneys also disclosed the lead lawyer, Michael Gottlieb, billed $2,187 per hour while working on the case, below his standard of $2,350. Wow, what a discount! I mean, it is a discount. I mean, that is what's the difference there? 3, 6. Oh, wait, no. Am I doing it backwards? Anyways, whatever. It's like at least a little less than $200 an hour that she saved. And I mean, with however many hours, I mean, I guess it is a deal. The request followed the dismissal of Baldoni's lawsuit in June 2025 and the eventual resolution of the remaining litigation in 2026. Someone named James says about James says he has nobody but himself to blame. Accidentally, meanwhile, his boys at Daily Mail and cronies at Team Baldoni deliberately and intentionally passed that wrong message around, claiming that was Lively's doing. What was Lively's doing? He recounted his deposition, so his word means as little as Blake Lively's. He also does ketamine, so who knows his frame of mind at any time. I mean, again, James ruined his credibility a long time ago, unfortunately for him. But at the same time, you still have to look at the evidence for what it is. But this James person is riding hard for Blake Lively, that's for sure. Oh, what did I do? Let me see. And the only other story was Blake Lively shares rare look at family life with Ryan Reynolds, and I couldn't care less. So Kenny's like, James, Ryan. Anyways, that's it. I mean, a little less than 2 hours. Is that a short live for me? You know, I don't know. Anyways, good night, everybody.